Have you ever wondered, do you need a revocable trust or an irrevocable trust? Well, in this video, I'm going to break down the difference between those two types of trusts and when you should use one versus the other. Okay, let's get started. All right, so when it comes to trust, setting up revocable versus irrevocable trust, there's a lot of confusion out there, and there's a lot of information when it comes to trust planning. Well, what I find many individuals fail to realize is that certain types of trusts, well, they're just not great for a lot of situations, and they should not even be considered because the perceived benefits that come from these types of trusts fail to materialize unless they're set up in a very specific way. And what I'm really getting into there is the irrevocable trust. So to talk about the two, I would want to just break it down for you and give you a high-level view of the differences between the two, and then I'll show you in which situations you should be using one versus the other. Okay, so a revocable trust. So a revocable trust is just that. That means that you can cancel this trust at any time. So if you have the ability as the trustor or the grantor or the beneficiary to revoke the trust and just throw it away at any point in time, distribute all the assets to yourself, then in that scenario, then that type of trust does not offer any asset protection. Now, what is that? Then why would someone set up this type of trust? Well, there's lots of reasons why you would set up a revocable trust. Is that you want to make sure that, hey, I want these assets out of my name, okay, for estate planning purposes, for asset protection purposes, or privacy is what I'm getting at there. But at the same time, I still want to maintain flexibility. So you're not looking so much for the asset protection, you're looking for the anonymity, you're looking for the estate planning benefits of it. You just got to get it out of your name. So what are some of those types of trusts that I'm referring to here? Well, the types of trusts that we're talking about here would be your living trust, okay? Your living trust is always going to be revocable because you wouldn't want to set it up so that you could never change it because things may happen in your life. Maybe a child now develops a bad drug habit and you'd set up your trust where they were to receive 50% of your estate and you did not enact a beneficiary control provision, or maybe you had one in there. And now, do you want the child with the drug abuse problem being in control of 50% of your estate? Probably not. So you want to have that flexibility so you can change it at any time. So that's why a living trust is oftentimes revocable. That is, we don't know exactly what's going to happen with our beneficiary, so I want to maintain that control until I've passed away. Now, another type of trust here that I often find as a revocable trust is going to be that land trust that I talk about a lot on this channel, about using it for real estate investments, for putting your real estate into the trust, and then having a ton of flexibility over how that asset is handled once it's in that trust name. Not to mention that it provides you anonymity. That's why many people will also set up a residence trust. So a residence trust would be a revocable trust. The difference between the residence trust and a land trust is that the residence trust is a strategy that we use to provide anonymity for your personal residence, to protect that from creditor attachment. If they get a judgment against you and they record the judgment, then it will not stick to your house. Maybe another one you might look at is a personal property trust. I'm just going to put PPT here. This is a great trust to use for a personal bank account. On some of my videos, I refer to this as a monkey trust, and people say, hey, well, I went to my attorney and he's never heard of the word monkey trust before. Well, there is no such legal term as monkey trust. What it is a personal property trust that's designed to take your personal checking account and again, get it out of your name, but at the same time, give you complete flexibility to pull money in and out at any point in time. So we're not locking anything down. So these are some common revocable trusts. They have a specific purpose, but they have a lot of flexibility. Now the irrevocable trust. Now that's a different animal altogether. So with the irrevocable trust, these, they're set in stone. You cannot change after you've set it up. So you have to make damn sure whatever you're putting into there and who's going to receive those assets, you're fine with it, because once that's set up, it's locked down. Now, when we set up irrevocable trusts, one of the benefits that comes from an irrevocable trust that does not come from a revocable trust is asset protection. Okay, so what am I saying there? That the assets held in an irrevocable trust for these beneficiaries, the beneficiary's creditors cannot gain access to those assets. Those assets are beyond their reach. That is, they can't break the trust and get into there and take the assets out. They can't force a distribution of the assets to make sure that they get paid. And that's why if you're weighing the scales here and we were to put various entities on a scale and say, all right, so here's my scale right here. And on this side, I have LLCs and corporations. And then on this side, I have an irrevocable trust, right, sitting over there. This side here is definitely going to be more weighted. It actually would fall down to here, meaning it's going to offer you more protection than these guys over here. And just by the nature of the beast, it's a type of entity we're setting up. And that's why I'm going to cover for you what type of irrevocable trust that you should consider if you want that type of protection. But understand what the limitations are. You cannot change them. And here's something else to consider. You can have a trust over here like a living trust. It can start in that quadrant as a revocable trust to begin with. And then when you pass away, it can fall down here into this quadrant. And that's what I was referring to when I was talking about a beneficiary controlled trust. That if you set up your living trust the right way, starts as revocable and then it becomes irrevocable and offers asset protection for your beneficiaries. Okay, so back to the irrevocable trust. So what are some common examples of irrevocable trusts that people will set up that provide asset protection? Well, number one, maybe a life insurance trust. So we set up these types of trusts to hold our life insurance policies. And we do that because we want to make sure that the policies, the proceeds that we received when we pass, that those proceeds are going to be held in a trust and they're going to be protected from the beneficiary's creditors and they're protected from my creditors. Maybe it's a whole life policy you have while you're alive, but it's also set up to avoid estate tax on those assets because it's considered to be a gift today. So when you set up an irrevocable life insurance trust, what you're doing is you're saying, hey, I am putting my life insurance policy into this trust for the benefit of the designated beneficiaries. I'm gifting it to them now. And I have no more rights to that asset. I've given it up, and that makes that trust irrevocable. So that's a common strategy there. Another one might be a qualified personal residence trust. I'm just create PRT. Now that's different than the residence trust I'm talking about up above, which is a revocable trust. So you can create a residence trust that is irrevocable. However, there are some limitations or some requirements that go with that many times people cannot satisfy, namely being that the house has to be free of a mortgage. It cannot be have any mortgage on it, or it makes this strategy difficult to implement. And again, this is another estate planning free strategy. But the most common strategy that people are interested in, we talk about in irrevocable trust, is what we refer to as an asset protection trust, which is self-settled. Okay, a lot of words there to unpack. What does that mean? So when we talk about an asset protection self-settled trust, what we're referring to is a scenario whereby you are creating a trust here, right? So you're setting up a trust and get this trust set up and you want to be the beneficiary. Okay, so you want to be the beneficiary of the trust because the other trust that I'm referring to, the qualified personal residence trust or an irrevocable life insurance trust, and there's other ones out there. Oftentimes, you're not going to be the direct beneficiary. You're not going to be the beneficiary at all of those types of trusts. You're transferring the assets to another beneficiary, but you're putting on controls and safeguards so you can control it while you're alive, and they don't get the benefit until after you've passed. But with the asset protection trust, when we say it's self-settled, what you're doing is you're setting up a trust where you're the beneficiary, and you're going to take your assets, be it real estate, cash, savings, stocks, and you irrevocably transfer them into the trust name. So you're going to transfer them over to this trust. And when you transfer them into the trust, the purpose behind this type of transfer is to put these assets, well, I can't say this is the reason we're doing it, but I'll just tell you why people do it, beyond the reach of a creditor, right? I mean, that's what we're doing many times when we set up a trust. I mean, obviously, that's what you're going to put in the trust agreement is that you've set up this trust because you want to provide for the control and distribution of these assets for multiple generations, and you're centralizing that in the trust. But that asset protection piece, I mean, come on, it's in the name of the actual trust statute when you set it up. So that is a reason for doing this. So when you move these assets in, when I say it's self-settled, that means you created the trust for yourself. Now, here's what you have to understand about these types of trust, is that they are a creature of statute, meaning not every state recognizes this type of trust arrangement. So if you're looking for a trust structure that provides asset protection and provides estate planning, because that's what this will do as well, and you're willing to give up some things, which I'll share with you, then you may want to consider utilizing an irrevocable trust or a self-settled asset protection trust. Okay, so what are the issues associated with this when it comes to setting them up? Well, you have to make sure that the state where you're going to create this type of trust recognizes it. For example, we set up our trust in Nevada. So we like to use Nevada. That is one of the states. Delaware is another one, Alaska, and there's several others, about, I think, 18 states now that recognize a North Dakota or South Dakota, I believe, a asset protection trust. And so the longstanding common law rule is that the law did not recognize trusts that were set up by individuals to protect their assets, meaning I couldn't just create a trust, put my assets into it, and then my creditors couldn't get into that trust and take my assets from me. The law just said, hey, listen, if you set up a trust where you're the beneficiary yourself of these assets, then we're not going to recognize it as a separate legal structure, and we're just going to assume that it's you. Since you have access to it, we'll give your creditors access to it. Well, what states have done is they've changed their laws. They've said, all right, well, that might be the common law. Well, the law of this state takes a different approach. So if you're looking for asset protection then, and you're thinking, hey, I need to use this trust, and I'll show you some ways in which you can use it and some ways in which we typically will set it up here. If you want to set up this type of trust and use it in this manner, then you have to establish it in one of the jurisdictions that recognize it. Otherwise, it won't work. For example, if you lived in California, you want to set one of these up in California, won't happen. You'll get zero asset protection, a creditor will blow through it. Now, when you set up an asset protection trust that is irrevocable, what you need to recognize is that you have to have an independent trustee. You have to have a distribution trustee. Distribution trustee. That is not you. Okay, so this person here, this distribution trustee, is independent. Now, oftentimes, that person must be located in the state where you form the trust. So we will form these trusts, as I stated, in Nevada. So out of our Nevada office, we use one of our Nevada attorneys to be the trustee of our trust. So now, people are not comfortable using or setting up this trust if they can't control the assets, right? Do you think an attorney knows how to trade crypto or stocks or real estate, something that you're into and that you want to put into this trust? Probably not, unless they work for Anderson, of course. So if you want to get asset protection, or you want to actually control your assets that go into the trust, then the way you set this trust up is that you name yourself, okay, so this is you right here, as the investment trustee. Okay, so you were the investment trustee of your trust. So you decide how all of these assets that are held in the trust are invested. The distribution trustee has no control. The distribution trustee will make payments to you, distribute the assets to you. Now, obviously, you can ask the distribution trustee for distributions, but you can't appear to control the distribution trustee, force them to make distributions. So there's very specific language that goes in here, because you have to create this appearance that your ability to receive funds from this trust is outside of your control. Now, this is essential to creating an irrevocable trust. Now, how do we go about then setting this up so we give you not only the control over the assets, which is kind of baked in, but also give you some distribution control? This is where the magic happens. So if you're thinking about using an irrevocable trust, then this is where you'd want to, how you typically would consider setting it up. So what we like to do is we like to create a Wyoming limited liability company. So we'll set up a Wyoming LLC, and then we're going to create our irrevocable asset protection trust down here. So I'm just call it a NAPT, a Nevada Asset Protection Trust. You will be the beneficiary of this trust. Okay, so you're going to be the beneficiary down here, and then we're going to use that same trustee stuff again, where I'm going to put an orange person right here. Here's your distribution trustee, and then this is you. You are the investment trustee. Okay, so you're set up there where you can invest the assets. Now, this Wyoming LLC, what's going on with that? Well, in the previous example, what I showed you is you're transferring your assets directly into the trust. And you could do that. You could change the accounts all over to the trust name. You could change title of the property over to the trust name. But what I would rather do instead is set up some LLCs. Maybe it's more than one LLC because we don't want to mix cash. If you're considering putting cash, stocks, liquid type investments, quadrant 2 assets, if you've watched my videos about how to break up your affairs, the safe stuff, you never want to put it with the real estate. So you could have a scenario where you have several LLCs going into this trust based upon the types of assets they're holding. Nevertheless, this is how you're going to do it. So let's assume I was just going to put in a brokerage account, investment account. So I would set up a Wyoming LLC with my stocks. Now I'm doing this again because I want asset protection. I want a higher level of asset protection that I gain just with that LLC. So I'll start off where I am the sole member of this limited liability company. So I'm the only member. And then I'm going to assign, transfer, move my interest in the Wyoming LLC to this asset protection trust. So rather than moving the actual accounts themselves, the accounts stay in the name of the LLC. I'm funding the asset protection trust with the LLC interest. But here's the trick. When you fund this trust with this LLC, you're not putting 100% in. You're putting in somewhere around typically 80 to 90% you'll transfer into this trust. And you will hold the remaining 10%, in my example, interest of that LLC, and you are the manager of this LLC, okay? So you're the manager. So what does that mean? You control the limited liability company. So all of the funds sit up here. The only asset that's held by this asset protection trust is an LLC interest. That's it. It does not hold the actual accounts. So the distribution trustee, the attorney we appoint as your distribution trustee in an asset protection trust, they can only distribute what they hold. And in this case, the only thing they hold is an interest in a Wyoming LLC. Now, obviously, I hold 10%. I don't need the other 90%. I'm going to leave it in my trust. Now, if you were to take this asset here, this LLC, let's assume that the LLC generated $200,000 this year, and you were to kick out 90% of that, or $180,000 to your asset protection trust. So you have a bank account and you distribute the money down in the asset protection trust. Obviously, the distribution trustee can move money out to you. Not a problem. They can say, here's 30K, here's 50K, whatever it is. But why do that? See, with the limited liability company, keep all your cash up here. And this is what people will do when they set up these trusts because they don't want to be working with the distribution trustee. Now, maybe you do it on occasion, but by and large, what you can do with your LLC to give you distribution powers and the investment powers, right? So now you're getting both with this strategy. You see, when I'm up here as the manager, I have the ability, because of the way we draft our operating agreements for our Wyoming LLCs, the distribution clause, this is critical. You have to have the non-pro rata distribution clause in your LLC to do exactly what I'm about to show you. You can decide to distribute to yourself as a distribution, as a 10% member, $180K. Now, some of you are like, wait a minute, you only own 10% and you made $200K. I calculate your distribution amount comes up to $20K. How do you take $180K out? Well, it's how you draft your operating agreement. You set up your operating agreement so distributions do not have to be based upon ownership percentages. In fact, when you give yourself more money like this, then it creates this debt you owe back to your LLC. Now, it's just you owe yourself money, so it doesn't really matter. But what we're doing there is we're even building up a greater creditor protection, meaning that if someone did sue you and they did put a charging order on your 10% interest, well, they're not going to get anything because yet 10% interest has an outstanding debt going back to the LLC. So even if you did decide to take money out down to this company, you would never distribute yourself any money because you have a charging order, and B, you owe the company a lot of money, meaning you've taken out more than you're entitled to. So all future distributions will just run to this company here and away from your creditor. So setting up an irrevocable trust is a great strategy if you need that enhanced asset protection and you want to lock things down for estate planning purposes, because these can exist for multiple generations. So oftentimes we find that physicians will want to set this up. People are in a high-risk profession, and what they will do is they'll do the strategy I just showed you. They create their NAPT, and then we create a number of LLCs. So maybe we have a cash or savings type LLC here. We have a real estate LLC here that owns other red boxes, like you've seen me draw many times in my channel. And we will transfer 90% of the real estate, 90% of the cash LLC into here. And then the individual will hold the 10% of this one and the 10% of this entity right here. And so what this strategy allows you to do then is control it, as I stated, and at the same time have the ultimate of asset protection. Now, the devil's in the details. That's why if you want to set one of these things up, I would highly encourage you to go into the show notes. There's a link to set up a free strategy session with an advisor in our firm, and we can walk you through and make a determination as to whether or not this is the right structure for you for where you're at today. And if it is, then you're going to find that should you run into trouble into the future, well, you're going to have a plan that makes it extremely difficult for any creditor to get after your assets. Hope you got a lot out of this video. And if you like it, be sure to smash the like button. Take care.